Crown and another against Central State for the Home Department.
Yes, Mr. Jaffe.
My lords, my lady, I appear for the appellant with Miss Negrelli. I'm grateful to the court for its permission for Miss Kerr-Morrison and Miss Dixon to appear remotely. My learned friends Sir James Eadie, Mr. Blundell and Mr. Pobjoy appear for the Secretary of State. My lords, my lady, under this scheme, the Vulnerable Persons Relocation Scheme, it's far more difficult for a vulnerable Palestinian refugee who's escaped the conflict in Syria to be resettled in the United Kingdom than a person in otherwise identical conditions of grave vulnerability who's not Palestinian. And the judge at first instance found that that was a breach of the public sector equality duty. And it's common ground in this court that if the public sector equality duty applies to this case, then it was breached. And essentially that is because an impact assessment was carried out, but despite the Secretary of State either being aware, or should have been aware, of the problem, the Secretary of State did not address it in her assessment. The sole issue for this court is whether or not the duty applies at all, essentially because the appellant is abroad. She lives in a Lebanese refugee camp. What I propose to do, with your lordships and my lady's permission, is to cover 6 points, mainly directed at referring to the submissions made by my learned friends in their written case. First, to summarise what we say is the correct approach to the territorial scope of the duty. Second, to deal briefly with the legislation, including some of the predecessor legislation, insofar as it casts light on what the current legislation means. Thirdly, a few of the relevant facts, which I can mostly take from the judgments below. Fourth, what we say are the principles to be applied by the court on the territorial scope of equality legislation. Fifth, section 1491A, which is the first limb of the public sector equality duty, and that will include dealing with the Secretary of State's argument that the Court of Appeal was wrong to find that the substantive rule under the Equality Act was engaged in this case. And then finally, I'll deal with section 1491B, and we say the analysis is different for that limb of the legislation.
Now, you've got quite a lot there to get through in 2 hours and a quarter.
Yes, well, most of it's going to be very short points.
Yeah, if it helps, I can assure you we've read carefully
Yes.
the judgments below and the parties' written cases, so we're pretty familiar with the issues.
I'm very grateful. First of all, by way of summary, we say that the position which has been reached as a result of the Court of Appeal's judgment is that the Secretary of State has a substantive obligation to comply with the Equality Act 2010, but not any procedural obligation to comply with any part of the public sector equality duty. And we say that is particularly surprising in relation to section 1491A, because that's, of course, a duty to have due regard to eliminate discrimination prohibited substantively under the Act. So if the substantive obligations apply extraterritorially, then our simple case is the territorial reach of the first limb of the duty should be at least as broad, because otherwise the legislative scheme, we say, read as a whole, makes very little sense. It makes no sense in our submission for there to be a substantive obligation not to discriminate, but an additional duty imposed by Parliament designed to impose procedural steps to help avoid that discrimination occurring in the first place, not applying. That's our case essentially on A. The case on B is a little different. There is a duty in B to have due regard to the need to advance equality of opportunity, and that's equality of opportunity between people who share a relevant protected characteristic and those who don't. That is not directly linked to the substantive provisions of the legislation in the same way. It's designed to be a more general duty. The way the Court of Appeal approached the case was to say that there was a strong presumption against extraterritorial effect that had to be overcome, and it hadn't been overcome. And our case is that the Court of Appeal was wrong in the circumstances, because applying this court's authorities, including those recently on extraterritorial effect, this is not a case where such a strong presumption arises. This isn't one of those cases where, for example, there is interference with the interests of other states or concerns relating to comity. It's not one of those employment cases that can actually often be analysed by reference to conflicts of laws, where the question is, should the case be determined under a foreign system of law or under United Kingdom law? Ultimately, we say the Court of Appeal applied an over-expansive view about what we mean by extraterritorial effect at all. Because not everything which affects someone who is abroad is something which Parliament isn't legislating for. And then finally, the Court of Appeal said that this was an impossible obligation to comply with in circumstances where I believe it's common ground that in this case and in many other circumstances, the government have sought to comply with this obligation, along with many other public authorities, for many years without apparent difficulty. And indeed, cases involving what the Court of Appeal would call extraterritorial effect have been considered by the courts for many years. And we've cited some of them in our case. Turning then, if I may, my lords, my lady, to my second point, which I'm going to cover very briefly, which is a couple of points on the legislative history and how the text of the duty has changed in relevant ways.
Can I just ask before you go on, do you need, for the purpose of this appeal, to succeed on more than one of these issues, or is it sufficient for you just to succeed on the section 1491A argument, let's say?
That is sufficient.
Yeah. Thank you.
Just on the legislative history, by way of comparison, there's been a change in the drafting of the duty over time. The first version of what has now become the modern public sector equality duty was in the 1976 Race Relations Act, as it was originally enacted. If I could invite the court to look at the different text of that very briefly, that is electronic 3355. And for those working on paper, it's volume 7, tab 74. It's 3355, electronic. And the original version of section 71 of the Race Relations Act imposes a duty on every local authority, so not all public authorities, just local authorities, to make appropriate arrangements with a view to securing their various functions are carried out with due regard to the need, A, to eliminate unlawful race discrimination, and B, promote equality of opportunity, and so on. So the duty was very different then. It was a duty to make only appropriate arrangements with a view to securing that due regard was given. It was not the wider duty as it now exists to give due regard generally when taking decisions. So the duty would be met simply by making a set of arrangements, perhaps in a policy. And it wasn't a duty that was relevant to individual decision making. That duty has then changed over time, and I'm not going to go through the legislative history, through the Greater London Authority Act, through the Race Relations Act, Race Relations Amendment Act 2000, to become the modern public sector equality duty in the 2010 Act. And the modern version of the duty, which was first seen in very similar form in the Race Relations Amendment Act, was introduced to give effect to the recommendations of the Stephen Lawrence inquiry. I'm not going to take the court through the references that we've given in our printed case, but the most useful explanation of how and why the legislation was changed into its current form is set out in the Home Secretary's report on the implementation of Sir William Macpherson's recommendations. That report is electronic 3282. That brings me then to the scheme of the current legislation. And I know the court is familiar with it, so I'm just going to make a few observations, if I may. If you'd like to have the text in front of you, it's electronic, page 423. And it's Authorities 1, tab 1. Subsection 1A retained the link to the substantive law that I addressed a moment ago. And we submit the purpose of this arrangement is it's designed to help prevent breaches of the substantive law before they occur by imposing a procedural requirement. It applies to the full range of protected characteristics, not just race, and it applies in relation to all the functions of the scheduled public authorities. So that includes the formulation of policies, and it includes taking individual decisions under those policies. There's then an explanation in subsections 3, 4 and 5 as to what the primary provisions mean. And the essential point about this legislation is that it is not a provision which applies to the world at large. It doesn't apply to individuals, doesn't apply to private bodies or companies. It's legislating for a scheduled list of public authorities acting as such. And what it does is it creates a form of mandatory relevant consideration for them to have due regard to when taking decisions. The degree of regard to be had is, of course, a matter for the public authority. There are then exceptions in Schedule 18. None of those exceptions are relied on by the Secretary of State in this case, but if I can just mention two of them. First of all, at page electronic 487, there is quite a limited exemption for certain immigration and nationality functions, which the Secretary of State accepts is not engaged here. And then at paragraph 5 on page 492, there is a power to amend the list of exceptions, and it's a Henry VIII provision in very broad terms. The Minister may, by order, add exemptions to section 149. So if on a proper analysis, it's the Secretary of State's view that the public sector equality duty ought to be narrower, we say Parliament has provided an appropriate mechanism, which comes with an appropriate level of accountability. An order under paragraph 5 is subject to the affirmative resolution procedure. I don't need to show it to you, but that's section 208 of the Equality Act. So that's the legislation. The court will be all too familiar with the substantive or the authorities on how the public sector equality duty has been applied. I think all I need to say for the purpose of this case is that it is not a duty of result, it's a procedural duty. The analysis of what level of regard is meant by due regard is ultimately a matter for the public authority. But as has been pointed out in this court and in other courts on many occasions, the duty is no less important for that. If there is one case which provides a convenient recent summary of all of the authorities, I would simply address your lordships to Bridges in the Court of Appeal, which I won't take you to it, but it's electronic 1674, tab 40 of the authorities. And in that case, what the Court of Appeal pointed out, and it's in particular between 176 and 182, is that it's quite a limited duty which doesn't require the impossible, but the purpose of the duty is to ensure that a public authority doesn't inadvertently overlook relevant information and material that it should be taking into account. And of course, the respondent in this case attempted to comply with the duty and produced a policy equality statement. It's just that the respondent failed to consider the difficulty which the courts below identified relating to the treatment of Palestinian refugees from Syria. The final aspect of the legislative scheme that I needed to mention to the court is the substantive law under the Equality Act, because there is, in effect, a respondent's notice point taken by my learned friend that the Court of Appeal was wrong about the substantive scope of the legislation. The relevant law is pretty much all in section 29 of the Act, and that's page 419.
Mr. Jaffe, we've got a technical problem with Lord Burroughs' laptop. I think we'll be better adjourn for a few minutes to let the techies see if they can sort it.
It doesn't seem to be charging.
For just a few minutes. If only all our problems were so easily sorted.
My lords, my lady, we're just looking at page 419 electronic, which hopefully Burroughs can now access. Starting at subsection 6, a person must not, in the exercise of a public function that's not the provision of a service to the public or a section of the public, do anything that constitutes discrimination, harassment, or victimisation. And then there is a specific provision relating to the territorial effect of that at subsection 9. So far as relating to race or religion or belief, to the granting of entry clearance within the meaning of the Immigration Act 1971, it does not matter whether an act is done within or outside the United Kingdom. So that's a provision which only concerns race or religion or belief, and the relevant act that section 29.9 speaks of is an act of discrimination, harassment, or victimisation, contrary to the rest of section 29, in particular 29.6. Now, I'll deal with the construction of this provision in slightly more detail later, but it is common ground, I'll say now, that this provision can't be read remotely literally. Nobody is likely to complain about the grant of entry clearance to them. It's common ground that it covers refusals, and it also covers the conduct leading up to a refusal, in the sense that an entry clearance officer may ask questions or make requests for information. And so those are the exact facts of the Roman rights case in the House of Lords, where there was particularly intensive questioning of applicants for admission as visitors who appeared to the entry clearance officer to be Roma. And that was held to be directly discriminatory, even though the discrimination occurred at the Prague airport, not in the United Kingdom. That was under the predecessor legislation, but it's the same provisions which arise. There's then a limited set of exemptions, and those limited exemptions, the relevant one is page 446 in Schedule 3. At paragraph 17. The effect of this provision is that a Minister of the Crown acting personally, that's subparagraph 3, can either take a personal decision or grant a general authorisation to permit certain types of discrimination. and it's not suggested that any Minister of the Crown has made such an authorisation here. The reason I show the court that is the same reason I showed the court paragraph 5 of Schedule 18, which is that Parliament has provided mechanisms if the Secretary of State considers that the scope of these provisions are too wide for what the Secretary of State properly wishes to do, to allow an escape. And the accountability mechanism is a personal decision by the Minister, and for which the Minister will, of course, be accountable to Parliament.
Sorry, I think I just got the wrong page for that reference.
I'm sorry, my Lord, it's
Yes,
page 446.
446, I see.
And it's paragraph 17 of
Yes.
Schedule 3.
Thank you.
And the relevant authorisation provision is subparagraph 3, which is the powers of the Minister.
Thank you.
And even these provisions come with some limits set by Parliament. So, for example, discrimination is permitted by a Minister on the grounds of nationality or ethnic origin, but not, for example, in relation to colour. So the Minister would be able to authorise discrimination in favour of or against nationals of a particular state, but not for or against, say, people who are white or people who are black. So that's the scheme which Parliament has introduced. Finally, on the legislation, there are the explanatory notes. And there's one provision of the explanatory notes we rely on at page 542 of the electronic bundle. And at paragraph 15 of the explanatory notes, in the 4th line, there is some commentary on the non-work provisions. And it says the Act is, again, generally silent on territorial application, leaving it to the courts to determine whether the law applies. And then there's a reference to the express provision made in section 29.9 that we just looked at. Now, that is a different approach than was taken in the predecessor legislation. So, for example, in the Race Relations Amendment Act and in various other bits of legislation, there were attempts by Parliament to delineate the territorial scope of the legislation. It led to lots of litigation, particularly in employment cases, and the approach that Parliament then started to adopt, and this history is described by Lord Hoffman in his judgment in Lawson and Serco, is that Parliament simply decided to stop saying anything about the territorial scope of provisions like this and leave it up to the courts.
What was the name of that authority?
It was Lawson and Serco, my lady. And the reference for that, again, I won't take you to it, it's Authorities tab 4 at electronic 735.
The explanatory notes to which you're referring, these are post-enactment notes issued by the government.
And they are admissible for what they're worth on the usual
Yes.
principles and subject to the usual caveats. What I say the court can take from them is relatively limited, but there is something. And the message is really that Parliament is content with the approach which is being adopted by the courts, a case-by-case analysis applying established principles. Well, that's my second point. The third one is a couple of the relevant facts for this issue. I'm not going to take the court through the facts of the appellant's particular case or the history of the scheme beyond saying this. The scheme was originally created in 2014. And when it was originally created, it was open to Syrian nationals only. That original announcement, again, I won't take the court to it, is at electronic 347. And the aim was to support Syrians only. Now, because that involved direct discrimination, it came with a ministerial authorisation under Schedule 3, paragraph 17 of Schedule 3 that we just looked at. Again, we don't need to turn it up, but that authorisation is electronic 345. This claim, as originally framed, was a challenge to that authorisation because the lawfulness of that authorisation was put in issue. Then, once this claim had been issued, the scheme was altered. And the way in which the scheme was altered was to remove the requirement of Syrian nationality. So the Secretary of State's intention was that those people who were fleeing Syria, who were refugees, and who were exceptionally vulnerable, because the scheme is deliberately targeted at people with particularly exceptional vulnerabilities that the United Kingdom can do the most to help, would be eligible. And they would be eligible on the basis of a referral from UN High Commissioner for Refugees. But in fact, even though it's accepted that the appellant meets the vulnerability requirements in principle, she's not able to be referred by the UNHCR, and nor has any other Palestinian been referred by the UNHCR, and that's because the UNHCR doesn't have a mandate to do so. The only Palestinians who have been resettled are those who are from a so-called mixed marriage. In other words, the person who is eligible is a non-Palestinian, and the Palestinian has been resettled as a family member. Now, I make clear that is not to criticise the UNHCR. It's simply the fact of them operating within their mandate. Now, when the scheme was expanded, the government prepared an equality statement, and that's the document that was designed to demonstrate compliance with the public sector equality duty. And if I could take the call to that very briefly, it's at electronic page 198. The document is not dated, but it dated from around, in 2017, around the time the scheme was expanded to remove the requirement of Syrian nationality. And dealing with the analysis of race at page 200, there's a heading halfway down the page, Equality Impact Assessment, Specific Groups, Race. It records that the scheme positively discriminated in favour of Syrians, and they were the only eligible nationality until July 2017, and there was a ministerial authorisation. Then there's an explanation of why the authorisation was reasonable, fair and justifiable, which is not relevant. And then over the page, at page 201...
Can I just ask, it's slightly curiously expressed, when it talks about we sought a ministerial authorisation, we considered, who are we?
The Home Office, presumably.
I assume it must be the officials who were deciding on the scheme sought a ministerial authorisation from the appropriate minister.
Yes, it's a Home Office document.
It's a Home Office document.
So the we will be senior officials.
Senior officials, yes.
Yes.
Describing their analysis. Then over the page, at page 201, there's an explanation of the change in the scope of the scheme.
It's bizarre. I mean, over the page, we have decided to change the scope of the scheme.
Yes.
Oh, so be it. That's a curious way of expressing it.
It is a slightly funny document in many ways. The second paragraph on 201 says there'll still be indirect discrimination, as it will favour Syrian nationals significantly more than any other nationalities. And then there's an explanation as to why that is thought to be justifiable. What there isn't in this document is there is no attempt to analyse or consider the particular difficulties of Palestinians.
Was the ministerial authorisation then adapted or removed or not needed anymore?
We understand it was revoked because the scope of the scheme had changed, because a decision had been taken that it would no longer be a scheme that was only open to Syrian nationals, which needed to be authorised by the minister. What we don't have is any document from the minister saying, I hereby revoke the authorisation, but we understand that was done. The reason I show the court this is because, as Mrs Justice Lane found, the policy equality statement contains no hint of any evidence that the position of Palestinians was considered, and that's why the learned judge found that there had been a breach of the duty. Just to complete the picture on the facts.
In your initial claim, presumably you flagged up the fact that the claimant was Palestinian.
Yes, well, there was an amendment, exactly.
There was an amendment.
Yes. Well, obviously, the original claim made clear that all of the appellants, there were 3 at the time, were Palestinian.
Yes.
And then there were amendments made to reflect the change in the nature of the claim once the scheme
clearly,
changed.
yes.
Yeah, that's right. But it was always...
The original challenge, you said, was to the authorisation, which would have excluded them because they were not Syrian nationals.
Exactly.
But it would have excluded a lot of other people who weren't Syrian nationals.
Precisely. It would have excluded, say, an Iraqi living in Syria.
So then the distinction between the mandates of the 2 UN bodies was not really at the forefront of the challenge.
Yes. What the judge did is the judge made some helpful findings of fact about what the Secretary of State knew at relevant times and what the Secretary of State should have known. This might be a convenient moment to show the court that. It's in electronic page 192. There are detailed factual findings in the preceding pages, but the judge explains why there was a breach between paragraphs 130 and 132. I won't read it out, but brief look at that.
And are we here dealing with a breach of both 1491A and 1491B, or?
What the judge found a breach of B,
Yeah.
and the reason the judge did not find a breach of A was because of her conclusion that the substantive law was not engaged.
Yeah.
And all I say is that the facts are a fortiori for the breach of A, because if there is a breach of B through failure to consider, as the judge put it, a puzzling obtuseness about the consequence of the different mandates of UNRWA and the UNHCR, if that also engages issues of substantive discrimination, then the same conclusion must flow. Indeed, we would say it was stronger in relation to A. And that was the only reason why the judge didn't consider making a finding under A. It was because of her conclusions, which the Court of Appeal ultimately overturned on the scope of the substantive law. And just for completeness, in response to Lady Rose's question, between paragraphs 28 and 32 of this judgment, there are detailed findings of fact which set out at some length all of the times on which the appellant and her lawyers sought to raise the issue with the Secretary of State, and all of the occasions on which it was either ignored or responded to inadequately. So there are detailed findings on that issue. My lords, my lady, that's my third point. If I can turn then to the fourth submission, which is what we say are the principles on the territorial scope of the legislation. And they do somewhat overlap, but first of all, we say ultimately, of course, the territorial effect of legislation is a question of construction. The task of using the usual tools, analysing the meaning of the words used by Parliament, reading the scheme as a whole. The way my learned friends put it in their written case is that they say there is a presumption to be applied, which can only be rebutted either by express words or by a necessary implication. We say that's not an accurate summary of the current law. We say the basic position was summarised by Lord Toulson and my Lord Hodge in Jetivia. And just to show the court that statement of principle, it's in Authorities Volume 2, tab 32, at electronic 1359. And just picking up paragraph 212, halfway down, it said, in the past it was held as a universal principle that a UK statute only applied to UK subjects or foreigners present and subjecting themselves to a UK jurisdiction, unless the Act expressly or by necessary implication provided to the contrary. And then it said that principle is involved into a question of interpreting the relevant statute. And then there's the citation of various other recent authorities to that effect.
So your submission is there's no presumption, it's just straight statutory interpretation, so to speak?
There may be a presumption in certain categories of cases, and examples of cases where there has been found to be a presumption are cases where, for example, there is an effect on comity, where there is an extraterritorial effect that interferes with the ordinary activities and legislative competence of a foreign state, or where there are genuine conflicts of laws issues which are engaged. So, for example, there's a question of whether a foreign system of employment law or a United Kingdom system of employment law ought to apply to a particular worker who works both in the United Kingdom and elsewhere.
But you don't start in a neutral position, do you? Saying there's no presumption either way. Let's just look at the legislation and see whether it has extraterritorial effect.
We submit that whether or not you start with a presumption and whether or not the thumb goes on the scale in a particular direction will depend on the type and nature of the extraterritorial effect involved. And there are some circumstances where there certainly will be a presumption. It may well become a very strong presumption. And there are other circumstances in which the court is much more willing to recognise an extraterritorial effect.
The example that's given at the end of this paragraph, Lord Sumption in Cox, is very close, it seems to me, to be to a necessary implication.
It is quite close, but it does ultimately go back to the purpose of the legislation as drafted.
Requiring it to have extraterritorial effect.
Yes, I simply say that on a proper construction, it's going to depend on all the factors and the circumstances. I'm not seeking to argue against the idea that the court may start in some types of cases with a presumption, but ultimately the text of the legislation, we say, is going to drive the outcome read in the relevant context.
So your scheme of construction would start by categorising the legislation. If the legislation falls within a particular category, that may give rise to a presumption against extraterritoriality. Therefore, you have to look more closely, but otherwise it's really an open question if it doesn't fit in to one of those categories.
And there may be circumstances in which we say the text is going to drive the conclusion, and we say that's the position in relation to Lim A, because there is an express link back to the territorial scope of the substantive provisions, and so we say it's clear what Parliament is intending on the text. In relation to B, we say the issue is more subtle, and it's necessary to look at what type of extraterritorial effect is proposed and the extent of the consequences abroad. And we say that's not only a principled approach, but it's the approach which has been consistently adopted by this court in recent years. Most recently in the decision in KBR, that decision, which if I can briefly take the court to it, is Authorities tab 9, and if I could ask the court to look at electronic page 980. And this is the judgment of Lord Lloyd-Jones, with which all members of the court agreed, and was considering the scope of the Serious Fraud Office's powers to require information to be produced that was held abroad. And then, having referred to the content of international law, Lord Lloyd-Jones explained that nationals travelling abroad remain within the personal authority of their state, and the state may legislate with regard to their conduct, subject to the limits imposed by the sovereignty of foreign states, and then says, as a result, in such circumstances, the strength of the presumption against extraterritorial application of legislation will be considerably diminished, and it may not apply at all. So that's just an example on those particular facts of how, whether or not there is a presumption, and the strength of any presumption is going to depend on the exact nature of the extraterritorial effect which is being alleged or asserted. Lord Lloyd-Jones then goes on to deal with what some of those relevant factors are. At paragraph 24, there's an explanation of the importance of comity, and just before letter C, the sovereign right of a state to regulate activities within its own territory. And then paragraph 25, that the rules of international law are one thing, but comity may take them even further. And so from the fourth line of paragraph 25, the presumption in domestic law is more extensive and reflects the usages of states acting out of mutual respect and, no doubt, the expectation of reciprocal advantage. So then those principles are applied to the facts. And then, just by way of example, at paragraph 28 on page 982, there's a record of my learned friend Sir James's submissions on behalf of the Serious Fraud Office. We don't need to concern ourselves with the details of that power, but it was a power to force the production of evidence which was held abroad, which obviously engages the interests of the foreign state in which it's held. And the final three lines, Lord Lloyd-Jones says, the more exorbitant the jurisdiction, the more is likely to be required of the statutory provisions to rebut the presumption. And there was nothing in that case to justify doing so. So we say the position will depend very much on the circumstances and nature of the legislation.
Yes, it means summarises at the start, the first sentence of paragraph 25.
My lord, that's right. Yes. Our second principle that we identify from the case law is that it's necessary to be quite careful in analysing what is meant by territorial scope and extraterritorial effect. The way that Lord Nichols put this point in Quark Fishing was that it's a slippery concept. And we say that the issue which arises here was analysed in most detail by Lord Roger in Alscaney. And if I could show the court the relevant parts of that judgment, it's an electronic page 786. Authorities, Volume 1, Tab 5. Skene is, of course, most commonly cited because it considers the territorial extent of Article 1 of the European Convention on Human Rights. But the other issue the court had to consider in that case was the territorial scope of the Human Rights Act itself, and whether or not the territorial scope of the Human Rights Act was back-to-back with the territorial scope of the Convention. So, paragraph 44, there is the quote from Lord Nichols in Quark Fishing about the slippery concept. 45, Lord Roger sets out the number of different policies which can be seen at work and refers in the fourth line to comity and international law, and the basic principle that it's inappropriate for Parliament to seek to assert its authority over the subjects of another sovereign not in the United Kingdom. And as a result, such provision would not fall within the legislative grasp or intendment of the legislation. And then some of the points going in the other direction are then set out on the next page at paragraph 46. Subjects of the Crown, British citizens are in a different position. And then Lord Roger explains why. And then concludes at paragraph 47, having analysed the case law, by saying that the cases indicate that British individuals or firms or companies or other organisations readily fall within the legislative grasp of statutes passed by Parliament. And so a lesser presumption or no presumption is being applied in those circumstances. Having identified those principles, Lord Roger then goes on to apply them to the Human Rights Act. And he does that from paragraph 53 onwards on page 789. And Lord Roger applies the same principles as would apply to a British citizen or a British company to the public authorities who are bound by the Human Rights Act. So at 53, it's pointed out the burden of the legislation, the Human Rights Act, falls on public authorities rather than private individuals or companies. Most of the functions of UK public authorities relate to this country and will be carried on here. Exercising their functions abroad would often encroach on sovereignty. But where a public authority has power to operate outside of the UK, and does so legitimately, gives the example of consent, in the absence of any indication to the contrary, when construing any relevant legislation, it would only be sensible to treat the public authority, so far as possible, in the same way as when it applies at home. So the approach being taken to territorial scope is different from the traditional approach in perhaps a conflicts type case of applying quite a strict presumption. Then over the page at paragraph 56, Lord Roger makes what he calls the crucial argument in favour of the wider interpretation of section 6, which is that the central purpose of the legislation, the Human Rights Act, was to provide a remedial structure in domestic law for convention rights. And so in those circumstances, it's only sensible and logical for the domestic legislation, the Human Rights Act, to have the same territorial scope as the convention itself, whatever that scope may be. And as the court will appreciate, we rely on that analysis in relation to subsection A, because we say that there is a direct link, just as Parliament was seeking to make convention rights in many ways subject to enforcement with limits in domestic law and the Human Rights Act. In subsection A, Parliament was requiring public authorities to have due regard to the need to avoid substantive discrimination. So the same type of remedial link. Demanding, we say, the same back-to-back interpretation. The third point of principle that we raise is that it's necessary for the court to consider whether there is anything in international law or the demands of comity which tell against extraterritorial effect. And the short point in this case is that there is nothing, we say, which tells against the limited extraterritorial effect which the appellant submits for. And that's not least, as we've set out in our printed case, because the promotion of good race relations and the avoidance of race discrimination are recognised in international law and long recognised in international law. We give the example of CERD, the Convention on Race Discrimination, and we also point out in our printed case that the International Court of Justice has said that Article 2 of CERD has extraterritorial effect in international law. Now, I don't rely on that as requiring international law to drive the construction of the domestic legislation. It's simply that indicates that there is not an exorbitant extraterritorial jurisdiction being taken by the United Kingdom in requiring its public authorities to have due regard. Put another way, it's relevant to the question of the construction of the legislation if the thing that we say Parliament is doing is permissible or impermissible under international law. We say there is nothing in international law which prevents or would seek to tell against Parliament giving the limited extraterritorial effect that we say it does.
So you're really saying it's of no concern and no offence to other states for public authority acting in Britain is required in its decision making to have regard to certain matters that affect people overseas?
Yes. Because that's a choice which is made and by a UK public authority acting as such in its decisions. That's all we say.
Does comity apply to the UN bodies? Do we have to respect a relationship of comity with them, or is it only in respect of other sovereign states?
I think that the doctrine or the principle of comity as identified by Lord Lloyd-Jones, I think was made clear to go broadly, and so would not simply involve a respect for the proper autonomy of other sovereign states. And of course, sovereign states are of course the basic unit of international law, but also where sovereign states have got together in order to create international organisations, where those international organisations have proper functions which have been agreed, then appropriate respect for their jurisdiction, I would accept, is a factor the court can properly take into account. That leads on to the final point of principle that we say the court should consider, which is what the nature of the task is for the court. And I've in a sense already made this point, that it will depend on the circumstances and the particular effect that is being proposed as to the approach the court will take. So there are cases which involve real problems of enforcement abroad and impracticability. So, for example, forcibly obtaining documents from a company abroad that may be prohibited under the law of the place where the company operates from handing them over. There may be real problems of usurpation of the interests of a friendly foreign sovereign or an interference with comity, because they're matters about which the foreign state would expect to have the sole right to legislate. But here what we're talking about is a duty of process imposed on public authorities by Parliament in their own decision making.
But it doesn't... Is it appropriate just to limit that, to say, well, this is extraterritorial, because you only have to have due regard to it. That doesn't actually require you to do anything abroad. But if the purpose of having due regard is that then you change the scheme in some way, don't you have to look at that stage in order to decide whether the requirement to have due regard has extraterritorial effect? Otherwise, you're automatically going to say, well, we'll have due regard to what happens abroad, but there's nothing we can do about that, so that's our due regard tick. But is that really a valuable extraterritorial application of this?
Well, let me answer that in two ways. First of all, does imposing a requirement of due regard mean anything in practice? Is it useful? Well, the answer to that, we say, comes from dicta that you see in cases like Bridges in the Court of Appeal, explaining the benefit of the public sector equality duty, and Elias in the Court of Appeal, where Lady Justice Arden, as she then was, explains the importance of the duty in improving the quality of public decision-making. And that's the rationale that was explained in the aftermath of the Stephen Lawrence report. So is it a beneficial duty which has some meaning? We say yes. I think that the other point that my lady is rightly putting to me is, well, is it possible that the exercise of the duty of due regard will then cause a problem, for example, a problem in relation to comity? And the answer to that, we say, derives from the limited procedural nature of the duty itself, because it's a duty of due regard. And therefore, the way in which it's exercised and the importance of the factors taken into account will ultimately be for the public authority. And where the public authority is concerned that its decision may have an impact abroad, it may properly take that into account. So, for example, one can see a case where an equality analysis is being carried out of a foreign aid decision, for example. And of course, this is what happens, because until this case, it was thought by the government that the duty did apply. It had routinely been applied for many years. In that analysis, there will be careful consideration of the social position in other countries and the way in which and the extent to which it is appropriate to give due regard to those various equality interests. So we say Parliament has already packaged that in to the limited nature of the duty. So this is not a case involving the forcing of an exorbitant jurisdiction. And where something is happening abroad and it involves the interests of the United Kingdom, then the public authority is usually going to be the central government, who of course has responsibility for the international relations of this country. And that is of course a factor which again can be taken into account on due regard.
Well, they've got to be transparent about it. And I'm just thinking, say you had a public procurement exercise, and the question was whether to purchase goods from Israel. Would the government have to have due regard to issues concerning the treatment of Palestinians? And if they did, following the approach of the judge in this case, they would have to spell it out in order for it to be clear how regard had been had to that question. Or it could be Uyghurs in China or whatever. And one could then imagine, well, in the first place, the government might not be very keen to spell out in black and white what it thought about the issue because of the possible impact on international relations. And then it might be judicially reviewed as not having made an accurate assessment of whatever the issue was by people who had a particular interest in it. What would be your comment on that?
The answer to that is that comes within the concept and must come within the concept of due regard. And as the case law establishes, what is due is not a question for the court. The regard which is due is going to be ultimately a question which is decided, if it's challenged, on familiar public law principles.
Yeah, but if it's a relevant factor, they have to, clearly, as you say, an assessment of whether proper regard was had to the factor would be primarily a matter for, well, the weight given to that factor would be a matter for the government, subject to review on familiar principles. But if they're meant to spell it out, what it is they've had regard to spell out what they've had regard to, would they not need to, well, for example, say the allegation is that, that Uyghurs are persecuted in China. Would they not have to have a position as to whether or not Uyghurs are persecuted in China, set out in a transparent way in their decision making?
Well, the first point is that there isn't a requirement to publish, for example, a decision in relation to every public authority's decision to show that the duty has been complied with. If there is a challenge, the duty of candour may require an explanation. Where that explanation engages questions of international relations, one can see how the court will apply its usual principles, perhaps, for example, of public interest immunity, if there is a good reason of international relations and the public interest why that question can't be answered, for example, in a public forum. One of the techniques that was used for dealing with precisely those issues were those adopted by the Divisional Court in Huarou, which was the case about the Chagossians, where some of the evidence engaged questions of international relations, because there were obvious questions of international relations in that case, in particular between the United Kingdom and the state of Mauritius and also the Seychelles. Some of the evidence touched on those extremely sensitive questions, and the court's solution was, rather than simply exclude the evidence through upholding a claim to public interest immunity, was to impose a confidentiality ring. So counsel, and only counsel, for the claimants were permitted to see some of the relevant material. And so where there is a challenge, there are techniques available for ensuring that the issue can be fairly determined. There isn't a requirement for publication, but the nature of the duty is one which is appropriate and calibrated for the circumstances.
I raised the issue of transparency because the judge's decision in paragraphs 130 to 131 was based on the absence of any documentary evidence to show that the issue had been considered. But that may not be your position. And I suppose the issue, it's not simply relating to the government, of course. If it may be a health trust or a local authority was thinking about purchasing Chinese products, then, to take China as an example, then I suppose they would have to show they had had due regard to the issue, to the sort of issues I've been discussing.
I don't suggest that the requirement of due regard goes that far. And that it would be proper for a public authority, for example, engaging in procurement of, masks during a pandemic, to choose to buy them in the circumstances from a Chinese supplier in Xinjiang rather than somewhere else. The duty is only one of due regard. It's a duty to think about things which are appropriate. And there are numerous judicial statements about the importance of keeping the duty within proper and appropriate bounds, and that in many cases something can be dismissed really without warning. That's not this case.
It has to be stated in the PES. I thought part of this public sector equality duty was to show everybody who is affected that these points have been considered. I'm slightly concerned by saying, well, it can all be dealt with by disclosing material into a confidentiality ring. But isn't the idea that the statement explains to the public what due regard has been given?
Where possible, that's a good thing. That is not a legislative requirement. That is a practice which is commonly adopted by public authorities in order to demonstrate their compliance with the duty. And again, there are numerous judicial decisions, Bridges, Bracking and so on, which say that whilst it is a good idea summarise it that way, to produce some kind of public statement as to how the duty has been complied with, that is not a requirement of the legislation. And there are, of course, many cases where public sector equality duty challenges have been dismissed, even though there was no public equality statement.
I'm not sure. Could you just explain to me why it is, looking at 1491A,
Yes.
when we're told a public authority must, in the exercise of its functions, have due regard to the need to eliminate discrimination, harassment, victimisation. Now, if that does apply extraterritorially, why would, for example, a health authority thinking about purchasing masks and not have to have due regard to whether the masks had been produced in forced labour camps by the victims of persecution?
That is something which they can consider, but the extent of the regard that is due in all the circumstances, for example, for a procurement decision, is going to be different from, for example, the extent of the regard which is due in a case like this, where the decision is really of a very different nature. And so the public authority is going to come back and say, well, what regard is due in all the circumstances, bearing in mind, if I'm a health authority, that ordinarily it's national government which decides whether or not the import and export of specific goods is permissible or should be sanctioned. Do I really need, in those circumstances, to carry out an assessment of a lawful import in all those circumstances? And so
you're placing a lot of weight on an interpretation of due. Are you saying... Sorry.
no, I'm sorry, I interrupted.
Yeah, yeah. I was going to continue by saying your submission would be, well, it may well be that when it comes to extraterritorial effect, particular approaches might be taken to the word due that might not be applicable in situations where we're not dealing with extraterritorial effect, but that doesn't preclude the application of the duty to extraterritorial effect. That in that sense the word due is perhaps a concept that has to be modified or in some sense nuanced when one's dealing extraterritorially, but it doesn't mean that there's no application of that duty.
Yes. So first of all, the duty of due regard. In a sense, I'm making the submission which is traditionally made on behalf of a public authority in relation to the interpretation of due, and it's a submission which has been accepted by the courts on many occasions, that what is due regard, providing an attempt has been made, is ultimately a question for the public authority and not for the court. And that's well established, and the authorities on that are summarised well in Bridges.
It seems to me we're dealing with two different things. The example of the local authority taking a decision to buy masks from somewhere, that is something that they are doing in the UK. And then the question is there a extraterritorial effect that they have in taking those decisions in the UK to have regard to trying to promote, eliminate discrimination, advance equality, etc., overseas? But here, aren't we dealing with a slightly different thing, which is that where the functions of the public official actually take place overseas and are exercised overseas, to what extent does the public sector equality duty apply insofar as there is extraterritorial application of the substantive provision to those functions being exercised overseas? That seems to be a slightly different scenario.
It is, and that goes back to the slippery question of exactly what the nature of the territorial effect that we're talking about here is, because the territorial effect here is one of entry clearance ultimately to the United Kingdom.
Yes,
So
so
it's
that's what I thought you were getting at when you took us to the cases about it should be coextensive with the substantive
Yes.
obligation. But I'm not sure whether your submissions are limited to the rather unusual provision which says that when you're doing entry clearance, which it was held was what was happening here, that is, even if you're doing that abroad, you are still bound by these substantive provisions.
But on this case, and I've already summarised what I'm saying about A, but on B I don't need to go further than to say it applies in the circumstances of the grant of entry clearance to the UK, which is a decision made by a UK public body to pass the border here and to reside here. And that's the nature of the power being exercised. It doesn't seek, for example, to impinge on a foreign sovereign. So let's say, for example, that the Lebanese government, for whatever reason, decided to decline to prevent my client from leaving Lebanon, refused to allow her to go for whatever reason, maybe a criminal charge, say. It doesn't seek to impinge on that, the fact of a grant of entry clearance. It doesn't impinge on the foreign sovereign in any way if a person is voluntarily permitted to depart from where they are. All that's being decided is something which ultimately takes effect here. And that's why I say the nature of the extraterritorial effects does have to be analysed quite carefully.
So just be clear, are you saying that the function that we're concerned with here, in terms of 1491, the function is the function described in section 29.9?
There are two different functions which are being exercised. One of the functions is the making of the policy.
Yes.
And that's the first function. But if I need to, of course, there's a secondary function, which is a grant of entry clearance. And both of them are policies which take effect in the way I've sought to describe, which is through ultimately allowing people to enter the UK under a quota for a particular purpose, and so on.
Well, the first, and I had thought, only function that we're dealing with, the first function certainly is a function exercised in the UK by governmental policymakers. If you're relying on the granting of entry clearance, are you saying that's a function here carried out by officials, British officials operating in Syria?
The Court of Appeal, and there was some evidence on this below, is that the function is exercised by entry clearance officers in Amman in Jordan.
Oh, in Jordan,
Yes.
yes.
Yes, so you distinguish then the procurement case, which is a matter of, the President's description of it, it's a matter of adopting policies to require foreign states to eliminate discrimination or harassment or victimisation from this circumstance, which involves policymakers making policy in the UK and British officials carrying out public functions overseas.
Yes. And I'm not saying...
You're saying it's not impacting on decision making by foreign powers.
Well, the example of procurement I was putting wasn't meant to suggest that there was any intention to affect the decision-making of the foreign government. It was simply, what I was envisaging was a procurement that in developing your procurement policies or making procurement decisions, the UK public authority, as I understand it on your approach, would have to have due regard to the need to eliminate discrimination, etc., overseas.
Well, there isn't a only under A, if there was an obligation on foreign public bodies not to discriminate, which there isn't. Under B, it's to promote equality of opportunity, which is a slightly different concept.
Well,
And so I think it's important to be careful about what is exactly being proposed.
well, the example I put to you of a health authority purchasing masks, right? a public authority must, in the exercise of its functions, now one of the health authority's functions is to purchase health equipment, obviously,
Yes.
have due regard to the need to, at this point my screen goes blank.
Eliminate discrimination, harassment,
no,
victimisation and other conduct, any other conduct prohibited by or under this Act.
I think it's B which is relevant, isn't it?
Advance equality of opportunity.
Yes, I think my Lord Reader's putting B to me.
Oh, either.
Well, under A, to deal with them in turn,
I mean, if for example, there's a tender from a state which practices harassment, victimisation, discrimination, and so forth, is that to be ignored, or is the public authority to have due regard to the need to eliminate that?
so under A, it is to be ignored because it's only discrimination, harassment and victimisation that is prohibited by or under this Act. And the foreign state will of course have state immunity,
Yep.
and there are limits to the scope of the legislation. So on my Lord's hypothetical example, I say A does not apply.
Yep, fine.
In relation to B, advance equality of opportunity between persons who share a relevant protected characteristic and persons who do not share it, we say that depending on the circumstances, that is a matter to which a public authority may need to have due regard to. But it will depend very much on the circumstances. And what, I'm not going to repeat the submissions which I made about what due regard is involved in the concept of due regard.
Thank you.
I hope that assists. I mean, in a sense, looking at it on a more parochial level, one parish council in Cornwall may have to consider, when looking at B, whether its decision has an effect on people who live in other parts of Great Britain, perhaps in the Highlands and Islands of Scotland. And in practice, giving due regard is not going to require very much in relation to most or all of their functions. It's going to be the unusual cases, such as this type of case before the court, where that duty of due regard has real and practical meaning, as the judge found it did. That leads me, subject to any further questions on that point, to my submissions under subsection A, which I've really already summarised, which is that there is an express link in subsection A with the substantive provisions of the Equality Act. So it just doesn't make any sense at all, we say, for the territorial scope of the public sector equality duty to be different from the territorial scope of the substantive right. None of the points which are made by the respondent really answer, we say, that clear textual link in the legislation. And I've already sought to draw the analogy with the decision of the House of Lords in Alscaney between the scope of the underlying convention rights and the scope of the Human Rights Act. The aim of the Human Rights Act was to provide a remedy to prevent cases from needing to go to Strasbourg by achieving a domestic resolution. And the same applies to the public sector equality duty. The purpose of A is to guard against and require thought to be given to the risk of substantive breaches so they can be prevented. Now, what the Court of Appeal said about this issue is in the Court of Appeal's judgment at paragraph 98. And paragraph, 96, and that's electronic 153. And it's halfway through paragraph 96. What Lady Justice Simler says is that although I've reached a different conclusion in relation to territorial effect, that's the point I'll come to, that conclusion is limited to the application of the rules to the appellant's individual cases and doesn't extend to the making of the scheme. And the judge's conclusion in relation to that still holds. as does her conclusion in relation to A in that connection. And we submit the short answer to that is that can't be an answer to the claim under A, because the public sector equality duty includes the individual consideration of the appellant's position. It's not the old duty in the 1971 Act just to make arrangements. And notably, I don't detect any real attempt to defend this analysis in my learned friend's written case. Their argument is put on a slightly different basis. Apart from their arguments about a strong presumption, the way the respondents put their case the respondent puts her case in this court, is that the Court of Appeal was wrong to say that the substantive provisions of the Equality Act were engaged. And that's the final point which I need to deal with in relation to subsection A. Just so the court can see the structure of the argument, the Court of Appeal identified two different mechanisms by which the substantive provisions of the Act might apply. And both of them have the same basic logic behind them, which is that the intention and purpose of the legislation would not be achieved if access to an entry clearance decision was barred by a discriminatory policy. There was a longer answer given by Lady Justice Simler based on a detailed analysis of the text of section 29.9, which I'll come to in a moment, and then there was a shorter answer given by Lord Justice Underhill, with which the other members of the court also agreed as an if necessary alternative. Because Lord Justice Underhill's analysis is the shorter one, if I may just deal with that first. That's in the Court of Appeal's judgment at paragraph 109 on page 157. At the end of 156. And the top of 157. And what Lord Justice Underhill says is that the decision whether to grant entry clearance in the case of individuals outside the United Kingdom is, as a result of 29.9, within the territorial grasp of the legislation, might be thought reasonable to infer that Parliament intended the same should be the case as regards the conditions of a policy governing how such decisions are to be made. And then says it's unnecessary to reach a concluded view about this because of the textual analysis conducted by Lady Justice Simler that all of the court ultimately agreed with. So that's the short answer and the short analysis, which we respectfully say is correct. Then there is the longer and more detailed textual analysis conducted by Lady Justice Simler. And if I could pick that up at paragraph 60 of the judgment on page 144. The first point made is that section 29.9 must cover refusals of entry clearance as well as a grant, because no one's ever going to complain about they've been discriminated against in relation to a grant, one imagines. And that was common ground and accepted by the Secretary of State. So, as I said, the legislation can't be read completely literally. It was also conceded by the Secretary of State, and this concession is recorded in paragraph 66 on page 146, that section 29.9 covers a process of testing or interrogation or questioning or analysis by an entry clearance officer, leading to a decision as to whether or not a person meets the requirements for admission. So we're not simply talking about the formal grant or the formal refusal, but also the steps and consideration which logically lead up to it, because otherwise the legislation would be entirely ineffective. Not a surprising concession, and then the explanation is given by reference to Roma rights at paragraph 66. Then Lady Justice Simler deals with the argument that, well, you don't even get to the stage of a decision by the entry clearance officer, a formal refusal, unless you've got a referral from the UNHCR. And at paragraph 67 and 68, she concludes that it's entirely artificial to try and separate out such a binding rule that prevents you from getting to the entry clearance officer from a refusal of entry clearance. And we submit that analysis was right. If it were otherwise, any form of discrimination, direct, indirect, harassment, victimisation, could be achieved lawfully simply by structuring a scheme as containing a policy, so the discrimination is front-loaded into the bit we call the policy, rather than the entry clearance decision. I mean, it's a bit like a rather old-fashioned tax avoidance scheme, where you slice and dice up the transaction so as to distinguish several parts of what is ultimately a single procedure. And as a matter of legislative interpretation, arrangements like that haven't worked in tax ever since Ramsey, 40 years ago. It doesn't reflect some special principle of tax law. It's just the application of ordinary principles of statutory interpretation in which formalism is rejected, particularly in a scheme which is not intended, we say, and plainly not intended by Parliament, to be read literally. Those are our submissions on A. Finally, my lords, my lady, there is the appellant's case on B. And as I've said in response to questions, that's only if we need it. It is sufficient for the claimants to be successful, we say, in relation to A. The substance of the argument, or the conclusion of the Court of Appeal, is that the Court of Appeal couldn't see and didn't accept why Parliament would want to achieve, for example, B, equality of opportunity, in relation to people or matters outside the United Kingdom. And so the Court of Appeal ultimately concluded that such a duty, and this is paragraphs 102 and 103, would be meaningless, because often the United Kingdom and its public authorities would have no capacity to achieve equality of opportunity abroad. What we say in response to that is that the basic question is and remains, what is the territorial intention or the grasp of the legislation? And we say it's drafted to apply to public authorities in the exercise of all of their functions, not merely some of them. We're talking about public authorities based here, exercising those UK public functions. And we say that that is sufficient of itself. And if that isn't sufficient, then in the circumstances of this case, there is certainly enough to justify extraterritorial application. And just to summarise the points I've already made, mainly in response to questions from the courts, what is the person or the matter, using the language the Court of Appeal used, outside the United Kingdom? Well, the person who benefits is, of course, outside the United Kingdom, here in a Lebanese refugee camp, when entry clearance is granted. But entry clearance takes effect, and has a legal effect, in the United Kingdom and nowhere else. There's no choice of law issue in this case. There's no question of a competing legal regime. And there's no question of comity, which might be engaged, because there's no attempt at interference with the prerogatives or interests of other states.
But isn't it a challenge to the limitation on the mandate of the UNHCR?
No, so the UNHCR simply has no mandate to conduct resettlement of Palestinians because the international community has decided that the UNHCR should not be doing that. That does not prevent in any way a state from seeking to resettle a Palestinian who has exceptional needs. And as the trial judge found, the technique that many states have adopted in precisely this situation is to allow referrals from someone else. For example, a specialist non-governmental organisation, or to allow individual applications to be made. So there are techniques for dealing with it.
So,
But
the point you're making is that the scheme, the matter, as it were, is that the scheme is with respect to persons who are currently outside the United Kingdom, but it's applied with a view to their entry into the United Kingdom. Is that? So, I mean, that's a sort of essential part of your analysis, that it's with a view to entry to the United Kingdom. If it was with a view to their employment at the embassy abroad, then this wouldn't be engaged.
it's very, very different circumstances.
Yeah, but I just...
Yeah, exactly.
So if the Foreign Office in London had a scheme for local or recruitment of local staff abroad, then that would not engage on your submission the PSED.
And what my lord is rightly putting to me is the facts of Hotak, which my lord will remember from the Court of Appeal, which is precisely that, where you had locally engaged staff in Afghanistan, and where the court found very clearly that the position was entirely different because there was a conflicts type issue of which system of law ought to apply to that employment contract. Ought it be the system of law contained in the Equality Act, merely because the employer was the United Kingdom or the Crown? Or should it be, like in any other person who was working full-time in Afghanistan, who'd never left Afghanistan, Afghan employment law, which of course was different, and it wasn't for the court to say which system of law was better. That's the nature of conflicts. But it's about deciding whether or not, or what the choice ought to be in relation to extraterritorial effect. And in that case, one can very clearly see that there are very substantial comity issues, because what the court would be doing is the court would be saying, well, okay, we think that it's necessary for us to apply our system of employment law throughout the world, even though it has effects on people who are employed elsewhere, and other states would say, well, hang on, why are you doing that in relation to people employed here who are nationals?
Section 1491, obviously we've looked at it many times now, requires a public authority to have due regard to a need, the need in relation to B, the need to advance equality of opportunity. And to understand your position is that Parliament has legislated on the basis that there is a need to advance equality of opportunity overseas.
Well, I don't need to go as far in this case, because as I've said, my primary submission is...
Is that not your position?
My primary position is that that's what Parliament has done.
Yeah.
But I've also said that if the court isn't willing to go that far, that it is necessary to have a look at what the person or the matter which is being analysed is, and that there is a lesser route through in relation to B, which requires the type of detailed analysis which is seen in House-Gainey and KBR and all of those other cases, as to what the nature of the extraterritorial effect being sought is. And the answer may differ depending on the nature of the effect. And here...
What you say here is the nature of the effect of extraterritoriality.
I say it's extremely modest, if anything, because of the factors which I've identified. So it's entry...
But what is it?
Well,
Can you express what it is?
It's that the person is abroad. The person who benefits is outside of the jurisdiction. And that is the extent of the extraterritorial effect.
Are you able to give me a yes or no answer to the question whether Parliament has legislated on the footing that there is a need to advance equality of opportunity between persons overseas?
Yes, there may be. And the reason for that is, let's say, for example, that I go on holiday for a month over the summer in a period in which a decision is taken in relation to me. The mere fact of my presence or absence from the United Kingdom does not affect that. Equally, take a foreign company which wishes to provide goods or services in the United Kingdom, which is not based here. Or a foreign individual who wishes to provide, for example, services in the United Kingdom. That is within Parliament's contemplation that the public sector equality duty would apply in those sorts of circumstances. So that's why I say that mere physical presence or absence of someone from the United Kingdom is not determinative, and that's why I say this is...
Your first example is taking someone who is resident in the United Kingdom and is temporarily absent. So I don't think that's an analogy at all, is it, with this case? Your second example takes us back to the Uyghurs, doesn't it?
And I do accept, and I do say, that the fact of physical presence or absence of a person who may be affected from the United Kingdom is not determinative. And one of the reasons why I say that is it's quite difficult to make this legislation work otherwise, because a decision may well affect lots of people, some of whom are in the United Kingdom and some of whom are outside. And so, just to give a factual example, there is the decision of the Court of Appeal in Elias about the compensation scheme for people who were interned by the Japanese during the Second World War. Some of the individuals who were affected by that were British citizens who had lived in the United Kingdom for all of their lives. Some of the people who were affected by the criteria had never lived in the United Kingdom, and some people affected had a more complicated factual scenario. The public sector equality duty, we submit, applied to all of their cases and circumstances. The due regard which needs to be given may need to be calibrated by all sorts of factors that I've already sought to identify. But I don't seek to avoid the conclusion, and I submit that Parliament didn't avoid the conclusion, that the public sector equality duty does apply by reference to these public authorities' functions. How it applies may be very different in all sorts of cases. But otherwise it just becomes, we say, extremely difficult to untangle in a principled way. And the final point is simply one that this decision is not one that seeks to take effect against the interests of any foreign sovereign. So there's no taxation power being taken abroad, there's no power to require something to be done which engages another state's interest. It can only ever be a scheme that operates on a voluntary and consensual basis. So if the appellant wasn't permitted to leave Lebanon, then she wouldn't be permitted to leave Lebanon. There's in no sense here any usurpation of the interests of a foreign state.
But what is the consequence of that? Is the consequence again that actually having due regard will only take you a moment, or is it that you accept that that influences whether section has extraterritorial effect or not?
Both, my lady. So I say that the duty is not one which is exorbitant, which is being applied, and secondly, that if the court is considering whether the obligation here is one which has that limited degree of extraterritorial effect, this is not a case where the court should be applying some strong presumption that extraterritorial effect was not intended by Parliament. In fact, the point may go even further, because one of the basic prerogatives of a sovereign state is to decide who to let in and who not to let in. And decisions relating to that are decisions which are very closely related to the United Kingdom's own interests and comity, and really are not the interests of other states. And finally, this is a scheme which, of course, does give rise to equality considerations both in the United Kingdom and also abroad. So it has an effect, for example, on fostering good relations between people who share and don't share protected characteristics in the United Kingdom, as well as abroad. And that goes to my point about the difficulties of disentangling some separate obligation or some limit on the obligation in relation to territorial effect.
Could you just expand a little on how C applies? I'm not sure I quite
I
follow.
don't make a claim under C.
You don't
in
make
this
a claim
case.
on C. No, I thought not. Okay.
I'm only relying on the effects in relation to B.
Yes.
And I'm saying that there are effects on B in this case which arise in the United Kingdom as well as abroad.
How? Sorry.
Because it does have an effect on equality of opportunity between people who share a relevant protected characteristic and people who don't share it in the United Kingdom. And so the relevant protected characteristic is being Palestinian. And equality of opportunity is defined in subsection 3 as including removing or minimising disadvantage suffered by persons who share it and don't share it, and meeting the needs of such persons. And admitting...
Who would be the equivalent person not sharing that characteristic?
a person who's not Palestinian.
I mean, I thought the comparison you were making were between vulnerable Syrian refugees who are Palestinian and those who are not.
Yes.
But in all cases, they're abroad.
No, it may also...
Once they're here, it's in a rather different... Or you say that even there's still the equality of opportunity, you say, between those who are admitted under the scheme and who are currently in the United Kingdom and those who, by dint of the circumstances you've explained, are in practice excluded.
My Lord, yes. The upshot of this scheme is that non-Palestinians secure admission to the United Kingdom and entry clearance to the United Kingdom under this scheme, but Palestinians do not. And so that is how there is an effect on equality of opportunity in the United Kingdom. Because those people who have enjoyed, and enjoyed is perhaps the wrong word, because these are people who are exceptionally vulnerable and require, for example, particular medical treatment that can only be obtained.
So what is the opportunity that you're discussing here then?
The opportunity is between the people who are admitted under the scheme, who are
The
non-Palestinian.
opportunity to do what, though?
The opportunity, for example, to receive medical treatment that can't be obtained in a refugee camp in Lebanon, which is an opportunity available to non-Palestinians, but is not available to Palestinians in practice. So, my lords, my lady, for those reasons we say that the claim under both subsection A and subsection B is properly founded. Unless I can assist the court further, those are the appellant submissions.
Thank you very much, Mr. Jaffe, and we appreciate your succinctness. Mr. James.
Was my lady, by way of introduction, and just to touch very, very briefly on the facts, as you would have seen from the judgments of the courts below, the appellant in this case has no connection with the United Kingdom at all. She is, at all material times, has been outside the territory. She is not a British citizen. She does not live or work here. She has no links at all with the UK other than simply the wish to benefit from the ex gratia scheme, which might lead to settlement in the UK. The background to and the details of that scheme I'm not going to take you through. We've summarised them in our case at paragraphs 6 to 10, and they're also set out very concisely in the judgment of Mrs. Justice Lang at 8 to 12, electronic page number 166, and in the Court of Appeal's judgment slightly more fully, because there was more of an exploration as to precisely how the scheme worked in entry clearance and all that, between paragraphs 7 and 25. And as you'll have seen from those paragraphs in the Court of Appeal's judgment, there isn't, as it were, an application to be part of the scheme. There is simply a reference or not by the UNHCR, and if the UNHCR decide not to refer, that's not a refusal of entry clearance, it's a decision that they don't fulfil the criteria under the scheme as applied by the UNHCR. Likewise, you can't make an application for entry clearance on the grounds that you wish to be resettled. There are, as you're probably aware, various categories of application that can be made for entry clearance. They're set out in the immigration rules, and resettlement is not one of them. But there is, in essence, as the Court of Appeal summarise, a two-stage process. The first step involves a resettlement question, referral or not by the UNHCR in accordance with its mandates. And the second step would be a visa application, that is an application for entry clearance, post-referral if one is made. So there is a separate process by which entry clearance is sorted out and dealt with. And at that stage you would have separate processes of the ordinary kind, biometric checks, national security checks and so on. Obviously of some considerable moment in the context of people who have left Syria. All of that is described by the Court of Appeal, as I've said. See in particular for that, that description of how the entry clearance versus policy process and distinction works. See in particular the Court of Appeal's judgment at paragraph 64, if you would. I wanted to turn then directly to the submissions as to how you approach the question which confronts you today, which is a question of general interpretation. You are the Supreme Court, and these questions come to you because they raise issues of general importance. And the generally important issue that is raised by this case is, does 1491, either in its entirety, or, and it might be thought the or is a bit strange if it's the outcome, or in any of its constituent subparts, a provision which Parliament intended to have extraterritorial effect in the sense of at least conferring benefits on people such as this appellant who have no connection with the United Kingdom at all. But so far as the principles that govern that are concerned, we do respectfully submit that the starting point, the correct starting point for the court, is a presumption that legislation is generally not intended to have extraterritorial effect. We derive that proposition from the range of authorities that are set out in our case at paragraph 33, including, from recollection, a statement by Lord Bingham that the presumption had, if anything, hardened over the years rather than lightened. But I wanted to take you only to one authority, so far as that is concerned, which is the most recent authority in this court considering those issues, which was the KBR decision. And that is in the electronic files at page 979. And it's the judgment of Lord Lloyd Jones. My learned friend jumped, as it were, straight into the deep end, around about paragraph 21, halfway down page 980. Can I just invite you to go back a page to the beginning of paragraph 21 under the heading, The Presumption Against Extraterritorial Effect, and the first sentence of that paragraph. The starting point, says Lord Lloyd Jones, for a consideration of the scope of section 2.3 is the presumption in domestic law in this jurisdiction that legislation is generally not intended to have extraterritorial effect. And I respectfully submit that nothing that he then says in any of the paragraphs that follow undermine the existence of that presumption. And I'll come back to paragraph 23 in a moment if I may, but just to divert without reverting to it, to the passage in the judgment of Lord Hodge that my learned friend took you to in Jetivia, which was, for your note or your recollection, at page 1359, paragraph 212. Our respectful submission is that that passage does not provide, and was not intended to provide, any support for some sort of proposition that the presumption that Lord Lloyd-Jones has just identified at the beginning of paragraph 21 does not exist. On the contrary, if that paragraph is read fairly and as a whole, and as I think Lord Richards pointed out, it thoroughly supports the existence of the presumption and the ways in which that presumption can be overcome, not least by the doctrine of necessary implication, which is the doctrine referred to by Lord Sumption in Cox, which is quoted by Lord Hodge at the end of that paragraph, 212. Lord Toulson, I'm so sorry, my Lord, I take your name in vain. Lord Toulson in Jetivia, but it doesn't undermine that. And one needs to be a little careful, if you still have page 980 open, one needs to be a little careful with taking sentences or passages in judgments out of context. If you go to paragraph 23 and you read the sentence or two that precedes the one that my learned friend placed particular reliance on, he placed particular reliance on the sentence between G and H that says, as a result, in such circumstances, the strength of the presumption against extraterritoriality may be considerably diminished, or it may not apply at all. Ha-ha, he says, well, there we are. But the problem with that submission is that in such circumstances refers to the previous two sentences. What Lord Lloyd-Jones is dealing with is the position of British nationals abroad, where traditionally different rules apply. And the court will be very well aware that there had for years been a live debate in Strasbourg in the same equivalent context of within the jurisdiction as to whether it made any difference or provided a sufficient jurisdictional link for you to be a national of the contracting state in question. Answer they ultimately come up with no or not very much, but here the position is dealing with British nationals abroad. That's nowhere near our case. And not merely that, but it certainly does not support a proposition that the presumption has disappeared or that you approach legislation and its extraterritoriality or not on a neutral basis. We would also note that when you're on 23 of Lord Lloyd-Jones in KBR, that is precisely the same point that is made by Lord Roger in Alscaney, at paragraph 47, which you were taken to, page 787 in the electronic bundle for your note. So there may be separate positions, separate principles and issues, jurisdictional issues of a well-known international kind in play when you are dealing with a position that affects British nationals abroad. So my submission is that all that one takes from the analysis of Lord Lloyd-Jones in KBR is the proposition, A, that the presumption applies, see beginning of paragraph 21, in all cases, that is the starting point, but B, that there are some cases, or there may in some cases be some factors more accurately, which would militate more strongly against legislation having extraterritorial effect. That is obviously a separate issue to the existence of the presumption. It goes to the factors which might overtop the presumption. And so far as those factors are concerned, unsurprisingly in KBR, one of the critical features that led the court to conclude that the legislation in question did not have extraterritorial effect, but was that in order for it to work, you might have to run your jurisdictional writ in America. And that would obviously be intensely problematic from the perspective of enforcement. And one has had that issue in various cases that have come before this court. I have a recollection of a case called Perry, in which there was the same sort of issue with the writ running in Israel. And I remember questions being put to me about whether it was my case that we could go after assets in London on the basis that someone had stolen something in Peking, which was a slightly problematic position to be defending. But that's the same sort of idea. So we do submit that the presumption exists. We submit that the case law is also clear on what is needed to rebut that presumption in principle. And what is needed, we submit, is either express language or a necessary implication. Now, of course, necessary implication, again, is a subject that has been considered by this court over the years, and necessary implication plainly must be considered having regard to the context, purpose, and subject matter of legislation. And there have been lots of cases that make that clear, but there have equally been a large number of cases that make clear that the test of necessary implication is a high one.
We haven't got any extracts from Benyon on this particular presumption, have we?
I don't think you have in the bundles. There may be some citations from Benyon in some of the authorities.
Right. It might have been quite helpful to have that
Well, I'm sure
as an overview.
I'm
Yes,
sure we
thank
can
you.
see if we can, between us, we can see if we can track some down. It may, Jennifer may be able to tell me it's already in the bundle. If someone could see if the bits are there. But necessary implication, test a high one, is the submission. That made clear in KBR that it would most obviously apply if the purpose of the legislation could not effectively be achieved without extraterritorial effect. So you put it kind of positively in that way. See KBR at paragraph 31. And for that proposition, he cited Cox at paragraph 29. I think from memory, it was Cox that was cited by Lord Toulson and Jativia.
Yeah.
Same point.
It was a joint judgment by Lord Toulson and myself.
Yes, so I was only half taking your name today.
That's right.
Authorship now revealed. You also will be very well aware of the well-known passage from Lord Hobhouse in the Morgan Grenfell case, in which a clear description of what necessary implication, or the rigour that necessary implication as a concept brought. And we've given you that and cited it in our case at paragraph 70, and have also pointed out, I hope correctly, that it was cited this time by Lord Reed in Miller. I think it was Miller 1. So presumption applies, rebut it by express language or necessary implication with all of the rigour that brings. One final point before I come on to the 5 key features of the legislation that we respectfully invite the court to consider here. My learned friend said, I think this morning, that there was an analogy to be drawn, and possibly even a direct application of the reasoning of Lord Roger in Alskaney. In particular, Lord Roger in Alskaney's analysis of the question of extraterritoriality of the Human Rights Act. And he said, well, there's a back-to-back interpretation, and you've got exactly the same going on here in relation to 149. We do not accept that submission is accurate. Again, as you will well recall, in Alskaney, the resolution of the question of the reach and scope of the HRA was ultimately and centrally resolved by reference to what has become called in the shorthand the mirror principle. It was designed to bring rights home, and it wouldn't make any sense if the same concepts scheduled to the HRA did not mean the same things and did not have the same reach of application. So if it didn't mirror, you would have to spend your whole life going off to Strasbourg to enforce things that Parliament had intended to bring home. That principle is plainly not in play in our context. Of course, the HRA was its own legislation with its own purpose, its own background and its own provisions, which are markedly and entirely distinct from the positions of the legislation that you are considering here. But in any event, it is not analogous. Its reasoning about the mirror principle or the back-to-back interpretation is in no sense analogous to the position under this legislation, not least because there is no equivalent principle under, say, Article 14 of the ECHR to the provision that you see in Section 149. Indeed, again, if I recall your case law correctly, the court has relatively frequently, or used to be relatively frequently, troubled with the idea that it was integral to compliance with substantive convention articles that you should do your process properly. And that was given its hiatus in misbehaving. And that line of authorities that said, no, if you are going to establish a breach of a substantive convention right, you better establish a breach of a substantive convention right. It doesn't matter what view the public authority formed of that, good, bad, or indifferent. So we do submit that the attempt to drag in, as it were, the mirror principle or back-to-back interpretation, if you want to call it that simply has no traction from the HRA into the context of the legislation that you are considering here. So that's all I wanted to say about the principles that are applicable. What then about the key features of this legislation and this set of provisions? The first point to make about 149 is the obvious one, which is that there is no express language which supports extraterritorial reach of Section 149. And we do submit that the fact that it is silent on the point is itself a strong indicator that Parliament did not intend the provision to have extraterritorial effect. One can contrast the position in relation to that state of affairs with other legislation which include the legislation that we've cited in our case at paragraph 68, namely 1341 of the Criminal Justice Act and 72, section 72(1) of the Sexual Offences Act. And indeed, the provision to which I will return in this very legislation, making specific exception and providing expressly for extraterritoriality, namely section 29(9). And we do submit, therefore, that the Court of Appeal Lady Justice Simler, in her judgment, at 101, if you have that to hand, page 155 of the electronic, we do submit that all parts of 101 are correct. She starts correctly with the presumption as a starting point, and then moves to this point about express words and what one can derive from the absence of express words in 149. That's the first point, shortly stated of 5.
She states the basis of rebuttal slightly more softly than you do, I think, when she says, unless Parliament can reasonably be taken to have intended to legislate for extraterritorial effect. It doesn't seem to be quite as high a test as requiring either express words or necessary implication, but I don't know whether she goes on to explain what she means by that.
My Lord, I don't think she does, and it may be that she didn't need to, because even if that was a lower test, she held it wasn't met.
Well, presumably.
But I made my submissions on the correct approach in principle, but even if that is a lighter test, I'm not sure it was necessarily intended to be, but even if it was intended to be a lighter test, she concluded it was not surmounted on the facts of this case. The second point is that there would be serious impracticalities and very odd consequences, including as to enforcement and the way in which the provisions work, if the very broad extraterritorial effect which my learned friend contends is adopted. And to some extent it goes back to a point that my Lord Reid was driving at this morning when referring to or asking my learned friend for the yes-no answer to the question whether Parliament truly legislated for there to be a need to do the things that we saw in 149, 1A and B. But one can posit the same point in a slightly different rhetorical question. Does it, that's 149, and all its obligations apply to the world if only you are dealing with public authority decision-making? There are two matters under this second point that are acknowledged in the case law as being particularly important in considering extraterritoriality, and that is unsurprising given that one is seeking to discern parliamentary intention as a matter of statutory interpretation. The first of them is the effect and extent of the extraterritoriality. That is obviously relevant when considering the operation of the presumption, the point being that the greater the effect and extent of the extraterritoriality which is contended for, the more difficult it will be to displace the presumption. See for that as a general principle at least, see paragraph 28 in KBR, where Lloyd Jones put it on the basis, as he said, that the more exorbitant the jurisdiction, the more likely to be required of the statutory provisions in order to rebut the presumption against extraterritorial effect, paragraph 28. And the second matter acknowledged in the case law to be particularly important relates to impracticalities, how it is going to work, enforcement and all of that. And again, that's acknowledged by KBR at paragraph 29. And so we would respectfully submit is oddity or incoherence of consequence if extraterritoriality is put in. I did want to remind you, before coming briefly to each of those things, i.e. breadth and then impracticalities and so on, to remind you of section 1493, because 1493, electronic bundle page 423, puts a little bit more flesh on the bones of what advancing equality of opportunity at least means. And you see various specific things to which regard must be had. Note in particular 1493C perhaps. And 1495, which obviously relates to C. Not directly an issue because my own friend is not relying on it, but nevertheless what we're doing is to try to work out what this section means and how it is designed by Parliament to operate across the range of its operation. So those two provisions need to be borne in mind. They were picked up by the Court of Appeal and cited by the Court of Appeal in paragraphs 34 to 35, and then introduced into the Court of Appeal's substantive analysis of 149 and extraterritoriality at 102 in the Court of Appeal's judgment, which I'm going to come back to because it's obviously an important paragraph. To start, therefore, with breadth under this heading, the appellant's interpretation would require a public authority to have due regard to promoting equality, fostering good relations and so on in respect of persons or matters outside the UK wherever a relevant decision is taken. That's irrespective of the fact that those people have no connection with the UK at all. My learned friend says in answer to that, well yes, but the PSED applies to a function exercised in the UK, and some here in this context of individuals will be granted or may be granted clearance to come to the UK as a result of the policy. But the answer to that is that all cases of or about extraterritoriality involve some sort of connection with the UK. Otherwise, there would be little, if any, debate about extraterritorial effect. And again, one keeps having bounces into the analyses that have gone on in the context of A1 ECHR jurisdiction, where in those early cases like Bankovic, an attempt was made to build jurisdiction onto the idea that the decision-making, in that case to launch the planes, to drop the bombs on the television station in Belgrade, had been taken in London, and that was enough. So there's always going to be some connection, but the answer that Strasbourg gave was, no, that's definitely not enough. You don't create jurisdiction or the sufficient jurisdictional link but simply by pointing to an effect of a decision that was taken in the jurisdiction here. And one can see that at work in the various cases as one goes through the bundle. So, for example, in KBR itself, the fact that a company was a US incorporated company with a parent company to a UK incorporated company was not enough to rebut the usual presumption against extraterritoriality. That was a case involving a clear connection with the UK through the intra-company connection between the two entities, yet it wasn't sufficient to rebut the presumption. By contrast, in Lawson and Serco, which you've been referred to by my learned friend, Authorities Bundle 1, tab 4, page 730 in the electronic, that involved a British national employed by a company registered in England who was interviewed in England, worked on an island that was a dependency of the UK overseas territory, was paid in sterling, given a no-tax code by the Inland Revenue because he worked on the island, and that was sufficient to rebut the presumption. So one can posit different fact patterns to test how that breadth works, as it were, what connections are sufficient. But the fact remains that their interpretation, my only friend's interpretation, means that those entitled to benefit from 149 and that 149 duty include those who are situated outside the UK, and it includes the promotion of equality and the fostering of good relations anywhere in the world. And so this case is one in which the extraterritoriality contended for is a broad one. But perhaps more significantly, more significant to the question, are the consequences of an extraterritorial extension of 149. And so far as that is concerned, we do submit that, with respect, that the analysis of Lady Justice Simler at 102 and 103 drives right at the heart of this issue, and that those paragraphs are correct. We do submit that it is incoherent as a legislative scheme to be subjecting the range of public authorities that are covered to obligations, for example, to influence equality of opportunity, where they may well have extraordinarily limited, if any, opportunity to effect that. How, I ask, could that conceivably be done by a UK public authority in any real sense? And to expand the analysis a bit further, because all parts of this are of interest to the extraterritoriality question, the same would arise, perhaps with knobs on, in relation to 149 at 1C. That's about tackling prejudice and promoting understanding. How could Parliament have intended public authorities to take steps to do this in foreign jurisdictions, in circumstances where the public authority will have no ability or authority to take any such relevant steps? And there may well be very different views on questions of equality, non-discrimination, what is a protected characteristic, what is not. As the Court of Appeal recognised, it simply cannot be for a public authority in this country to determine how best to advance equality of opportunity for people subject to foreign law, traditions and customs. And that sort of point lay at the heart of the reasoning of the Court of Appeal in 102 and 103. And the strength of the point is, if anything, amplified when one considers the range of bodies who are captured by 149 by operation of Schedule 19. Parish councils, national park authorities, NHS trusts, the police, and of course, the main governmental departments, including, one might add, the FCDO, the Foreign Office. And one can immediately see the difficulties if in every relevant decision taken by the Foreign Office it has to consider the extent to which its decision, which almost by definition every decision it takes is going to be in this foreign relations sphere, if every decision, does it advance equality of opportunity for persons outside the jurisdiction or doesn't it? Sanctions, foreign aid, procurement, you've discussed a bit this morning. And I do submit in making these points about 149B and indeed C that it is correct as an approach of interpretation. I perhaps should have made this at the outset when dealing with the principles that are to be applied. It is correct for this court to raise its eyes to the broader hills, because the meaning of a provision in primary legislation like this must be constant across its range of application. And those difficulties were difficulties to which my learned friend really did not have a sensible answer. My Lady Rose put to him this morning a question about how is all this going to work, was the thrust of the question. Of course it's a due regard duty. Of course there's no duty of achieving a result in the foreign country. Of course one's got to take a step back. But ultimately the question, if I understood it correctly, was you've got to focus, haven't you, on action as an indicator of the scope of due regard. Because if you can't influence the action...
Just now, you said public authorities have no ability or authority to take any steps to foster what needs fostering or advance equality of opportunity. But I think what's put against you is that this isn't about taking steps. This is just about having due regard to this need.
My lady, yes, but if you go back to 102, 103 of the Court of Appeal, they're entirely alive to that you have to step back from steps which it isn't about to due regard. But the two are interlinked, because if you have no capacity to influence or do anything to foster good relations or to advance equality of opportunity in the foreign country or in relation to the foreign state of affairs, then how can this be something that Parliament intended you to think about in those terms, to have regard to have due regard to? And that, as I understood it, was my lady's question to Mr. Jaffe. How does that work? And his answer was twofold, and neither goes to the substance of that question, I submit. The first answer was to say, well, it improves the quality of decision-making to have these duties imposed on public authorities if they're operating in the United Kingdom. Well, no doubt generally that is right, but it doesn't address the concern which the question raises. And then my learned friend said, well, the second answer is that it's possible or it might lead to comity, but again, we haven't got a comity concern here. So he said, but again, that isn't the concern. The concern is that if you can't do anything about something, is it really useful to have due regard to it? That is the difficulty. I did want to touch on a point about comity, although comity may be calling it something which it isn't. It's really related to the questions that my Lord the President was asking of my learned friend this morning to do with transparency. And we do submit that it is not accurate to say that there is no comity concern or anything of that kind here, and so you don't need to worry about that, and as a result you can perfectly happily impose extraterritoriality and no one will worry about that. Now, of course, we are not dealing with the situation that was being dealt with in KBR, where your jurisdictional writ had to run in the foreign jurisdiction. No one is remotely suggesting that. We're not dealing with coercive powers operating in a foreign jurisdiction.
But it is evident, I submit, that it is evident that those sorts of considerations, those sorts of issues and difficulties, foreign relations sensitivities, if one wants to call it that, may well be engaged here. It's not international comity in the sense that you're trespassing on another state's jurisdiction. It is international comity because if a part of this regime of creating due regard and then the process being gone through and it becoming public, if the thing becomes public, that must be the working assumption, there will be very serious, or may well be very serious, impacts into those broader public interest features such as foreign relations. And that is for pretty obvious reasons. One can envisage, depending upon the breadth of the reach of these provisions, one can envisage any number of situations from healthcare trust to the Uyghur to the every decision the Foreign Office ever takes about anything. One can well envisage situations in which the move into dangerous and difficult waters of that kind happens very, very quickly. And it is not a good enough answer to that to say, well, you don't have to bother with any of that, because there are doctrines and principles, which there undoubtedly are, which courts can bring to bear in the context of a court challenge to protect information. The fact of the matter is there are lots of regimes that put government information, public authority information into the public domain, including the entire structure of the Freedom of Information Act. But more fundamentally, the 149 process is indeed designed, in most cases, to explain to the public why it is and how it is that various decisions have been made. So it isn't an answer to these concerns to say, don't worry about it, we can always keep it behind wraps. You won't be able to. And on that basis, therefore, we do submit that that is a powerful and at least interesting feature of the extraterritoriality debate in relation to 149, because the question that it poses is whether Parliament truly intended to impose a duty publicly to explain why it is that we think the Chinese are behaving badly or not in the context of the Uyghur in public as part of this duty. That would be the more significant. One can use exorbitant in a slightly different sense to the sense in which Lord Jones was using it in KBR. The more surprising and dangerous and difficult the potential consequences, the more one would expect Parliament to be very clear about extraterritoriality if that truly was the intention.
Well, one can imagine. I mean, clearly, the UK has many strategic allies or business partners who don't observe the same standards or have the same views about equality as we do. And I mean, one question is whether Parliament can be taken to have intended that, say, the Ministry of Defence or Department of International Trade or the Foreign Office should be having regard to these issues in its decision-making, and also whether it can be taken to have intended that the department would have to explain itself if its decision-making were challenged.
And with all of that, I respectfully agree. And the examples are myriad. In relation to, they may be surprising for different reasons in relation to lower grade public authorities, as it were, but in relation to central government, one sees the difficulties very, very, very quickly, and they are significant, I submit.
But if this provision does not apply extraterritorially, but the Foreign Office takes a particular decision which is then challenged on rationality grounds or other grounds, if it is argued that a factor which the Secretary of State ought to have taken into account and it was irrational not to take it into account and it wasn't taken into account is one of these factors, then that will be relevant to the assessment of the legality of the decision, regardless of whether this provision applies or not?
My lady, it may be. Think Venn diagram is, I think, the answer to that. I mean, there may be situations in which there is an overlap between the sort of subject matter areas that 149
Yes.
broadly is dealing with and the concept of rationality.
Yes.
It is not necessarily the case that all of these provisions
No,
and
no,
duties would
but-
apply as aspects or ingredients of rationality necessarily.
No, but there may be a decision which is taken in which it is, one might say, well, these kinds of things, or a particular question about the conduct of the foreign state,
Certainly.
ought to have been taken into account and wasn't.
Yeah.
And that would then be a ground for challenge, successful or not, regardless of whether this particular provision applied.
So if your question is, are there ever cases outside 149 in which government is confronted with, presumably pursuant to its duty of candour, with having faithfully to explain to a court the basis for its decision-making, and it included reasoning and or a conclusion which might create the sort of sensitivities that I've described, my answer to my lady is to accept that. Of course that's the position. Again, I can think of any number of examples of that even in the last 3 months. And so it happens all the time, and there are mechanisms for dealing with it. My learned friend is, of course, as ever, half right, because PII does exist to provide protection in certain circumstances for that, and he gave you the example of the Chagos Islands, which we did against each other, in which there were confidentiality rings set up to deal with some parts of the international relations PII basis. There were other confidentiality rings set up to deal with the worry about collective cabinet responsibility. There are mechanisms for protection and for having that debate between the public interest in ensuring justice and the public interest in the protection of it. But
As I understand the gravamen of your point, there may be decisions, public decisions, where some of the matters listed in 149 are, quite apart from 149, relevant considerations.
Yes.
But your criticism of this provision is that, or the interpretation of this provision as extraterritorial, is these matters are being made by statute as necessarily relevant conditions.
Exactly so. Exactly so, across their entire range.
Yes.
I mean, if for example, the issue was, say, sales of fighter aircraft to a Gulf state.
Litigation 1 month ago,
Right.
in the High Court.
And say the argument was that the Ministry of Defence or the Department of International Trade, whichever one was involved, should have had regard to the need to advance equality of opportunity between people in borough, in wherever it might be. I mean, the first question for the court would, absent Section 149 as construed by Mr. Jaffe, the first question would be, well, is that a relevant consideration?
That would be a matter of rational judgment for the Secretary of State.
Yeah, and that might be where the case ended.
Yeah.
If it was a relevant consideration, then obviously there would then be an issue about whether due regard was had to it.
Yeah.
But on the construction that's being argued for, Parliament has decided that it's a relevant consideration.
Across the range and in all cases,
Yeah.
I think was the point that my Lord Hodge was making.
Exactly.
Exactly so, and that's very, very different. And I said, sorry for adding as my Lord was speaking, as it were, but I said that would be judged by reference to rationality, and it would. There is very clear authority, which you'll be very well aware, that in deciding what to consider in any particular decision, ordinarily as a matter of public law, it's for the Secretary of State to decide on rationality grounds whether to take it into account or not. I think of the Wallboys case, DSD, in the Divisional Court, and others, Cartoon and all that line of case law. So
Very polite. It was I that interrupted you.
Yes.
It wasn't you that
Apologies.
interrupted.
Apologies all round.
Now,
That's indeed the moment.
very well. We'll adjourn then and resume at 2 o'clock.